Okay, at this point, I'm going to go back to the land issues and creek removal and the findings of facts of federal recognition, 131 pages. In the year of 1817, center stage shifts from southern Alabama to Washington, D.C., relative to events affecting the history of the Porch Pan of Creeks. In January of that year, the claim of the Friendly Creeks as a whole are considered and being reported out of the Committee of Ways and Means. Mr. Lowndes of the committee concludes that, quote, it will be best to appropriate a definite sum to be applied under the direction of the Secretary of War to indemnify Friendly Creek Indians for property destroyed by the hostile Creeks in fair proportion to their losses. United States Congress, 1832. While no remuneration was paid out at this time, this report preceded the later payments and set the responsibility for payment on the United States. 2 months later, an act was passed by Congress which played a crucial role in the history of the Porch Pan of Creeks. On March 3, 1817, a bill was enacted which provided that fee simple patents would be issued to the heirs of land grant recipients under the Treaty of Fort Jackson, a significant departure from the original plan under which rights of occupancy would inure to the heirs as long as they did not voluntarily abandon the land. The act also provided for the appointment of claims agent, a special commissioner, and in December, President Monroe chose former Georgia Governor David B. Mitchell to this post. Mitchell's mandate then was ascertain the damages to the Friendly Creeks, to arrive at a definite sum, and to take evidence on the land occupied by such claimant. Okay, so there you go. The docket 272. For those claiming a section of land under the Treaty of Fort Jackson and modified by the Act of March 3rd, 1817. Several of the half-bloods who were entitled to land, as it turned out later, were not in the vicinity. Yet, of 39 land claims under the Treaty of Fort Jackson, 27 were filed by members of half-blood community in southern Alabama, yet only 30 were processed, and of December 20th, 1826, following an April 12, 1820 date of certificate, the remaining 9 were processed at varying times up to 1828. The 30 land claims which were processed, of which 25 were those of relations and ancestors of the Porch Pan of Creeks, appear in Volume 14 of Public Land Documents in the American State State of Alabama to deed lands upon which the Porch Consolidated Indian School stood to the United States to be held in trust for the Porch community. At that time, however, there was no criteria for federal acknowledgement at any systematic procedure to evaluate such petitions, so that no action was taken immediately. Governor Wallace formalized his offer of deeding land in a letter to Commissioner Thompson, September 15th, and was followed by another letter from the Native American Rights Fund, which was headed at that time by Eddie Tullis, reiterating their earlier request. This request precipitated a study ordered by Commissioner Thompson in order to determine the legal status of land and the history of its granting and transfer. After the exhaustive study of the Office of Trust Responsibility in the Bureau of Indian Affairs, Commissioner Thompson issued a memorandum to the Associate Solicitor to the Department of Interior, stating that a positive evidence of record supports the claim that March 3, 1817 statute had no application to the Lynn-McGee Reserve secured under the 1836 statute. The land claim issue for the porch ban of creeks is still unresolved. And once again, I state Commissioner Thompson's memorandum and the Office of Trust Responsibility, if in fact an exhaustive study even happened, they themselves, depending on what time this study actually took place, was wrong, because the applications for docket 272 and for the those claiming payment to the Friendly Creeks under the March 3, 1817 Act for the damages to the land grant recipients, the allottees, didn't actually take effect until later on. Even though the land claims for docket 27 was heard in the 70s, I don't understand how, with an exhaustive study, that all of this couldn't have been resolved. Unless, because the applications weren't actually sent in until 84, and the cutoff for these applications was in 1985. So of course those issues weren't resolved, and here I'm resolving them. Land Resource Committee, Select Senate Committee hearing for the disposition of docket 275 and the remaining funds, the mass overage of the remaining funds in docket 21, where this is Eddie Tullis' statement. However, in 1924, the Department of the Interior illegally issued a land patent to one of McGee's descendants. Well, the land patent was not illegally issued to one descendant because it was under the Treaty of 1817. Or excuse me, not the treaty, but the Act of 1817. There was only a certain amount of time that the lands could not be alienated in order for the patent to be issued. Nonetheless, in Eddie Tullis' statement, in the highlights, October of 1975, NARF attorneys, Native American rights attorneys, replies that the Creek request is not for recognition, that in fact they already have it in the form of trust land base. The fact that his land base, talking about Chief Fred Walker, his land base has been alienated through administrative errors, which the administrative errors is where the lands were sold on the county court steps, assessed for taxes to owner unknown after the land patent had been issued, does not terminate the trust status. So, and then in December of 1975, Secretary of Interior Klemp informs the presidential assistant who had inquired into the matter on behalf of the Creeks that the department is in the midst of some confusion about federal recognition, and the Creek contention that they already have it will take time to investigate. If in fact an investigation had been made and all of the documentation had been submitted at that time through the Indian Claims Commission judgment fund distribution for docket 272, then they would have seen that the land claims were resolved. The issues for the lands were resolved. So, being that the 1817 Act directly connects to the Treaty of 1814, and in between directly connects to the Treaty of 1832, where the Creeks had the option to remove or to stay, those who remained under the treaty were provided I'm going to stop here.